Glad to see such a large crowd here, and for me it's somewhat unusual to walk into a room and take the stage at the top without everybody standing up, so it's quite refreshing from that point of view. I'd like to welcome everybody here, and in particular a large number of social workers, many of whom from my own part of the world up in Donegal. It's great to see all of you here. Some of you have been absent from my courts for a while due to family reasons, but it's great to see you all here. A large number of guardians and a variety of other professionals, all of whom have expertise in the field of childcare. In particular, I'd like to welcome those who have travelled from the northern part of the island. And it struck me as I woke up to the shocking news this morning that if this conference were being held in a year's time, you might have to get visas and have border checks on your way here. So hopefully that won't be the case. Today's conference has been organised by Tigala, the Independent Guardian Ad Litem Agency, and I think you'll agree that the lineup of speakers that has been put together by Morag and Megan and Eugene and Claire is most impressive, and I'm sure that their contributions and presentations today will more than match their very extensive qualifications. The focus of the conference obviously is on a particular aspect of childcare work, and maybe child sexual abuse reporting, which is probably the most difficult and most contested area of childcare work before the courts. Just a couple of general observations, if I may. Children, we're told, according to the chair of the Child and Family Agency, Nora Gibbons, in an address she gave some time ago, make up 25% of the population of the island, 1.15 million people. At the end of 2014, there were 6,500 children in care, and in the same year, 42,000 reported concerns had been made to the Child and Family Agency. So that gives us an idea of the scale of the problem. I think when Morag was speaking to me about this, she wanted to make sure that the focus of the day was, as she put it, to walk in the child's shoes, and that we should all try to view this through the prism of the child's perspective. And too often in the welter of allegations and counter-allegations and arguments about law and evidence in courts, the child's perspective is forgotten. And it's our duty here, and I think every single person in this room takes it very seriously, to achieve the best possible outcomes for children involved in these processes. And that comes under a variety of headings, some of which are going to be addressed today, obviously medically, in the case of sex abuse, psychologically, emotionally. The child may be subject to, or an unwilling participant or subject of proceedings in the criminal courts as a witness, prosecution witness, in the family courts in disputes between the parents over custody and access, and finally in the childcare courts where the Child and Family Agency are seeking to have the child taken into care. And finally then there are a whole variety of informal and voluntary care arrangements which arise. So it's a complicated, complex business. Because this is a Guardians Ad Litem, if you like, organised event, the focus inevitably is going to be on the court processes. So I'm just going to very briefly give you one or two thoughts from the perspective of the judge hearing the case. When we're hearing these cases, we have to focus on the individual case, so we're not at liberty to maybe make comments about how we see the type of work being carried out generally. One of my colleagues, who may be known to you, Brendan Toll, who specialises in childcare cases and does nothing else in the Dublin Metropolitan District, has described dealing with childcare cases and the case management of them as trying to nail jelly to a wall, and I think most of us would probably empathise with that. But judges, at the end of the day, have to make the decisions, and most of us here will be familiar with a very controversial case in the UK only this week, where a childcare case or childcare order had been overturned by a very, very senior, in fact the most senior family law judge in the English High Court, only for the father concerned to be recently convicted of the murder of the child who had been handed back to him. That is a very chilling reminder of the fact that we don't always get it right, and that judges who hear these cases do so very conscientiously, in my experience. They make every effort to listen carefully to all the evidence, to give every side a full opportunity to make their case. and to take into account both the law and the evidence and try and make a decision that's the best one that they think on the basis of what they've heard for the particular child involved. And as I say, that case is a very chilling reminder of the fact that, you know, judges aren't infallible and don't always get it right. Somebody, I think it was Daphne Primrose, observed to me last night that if a doctor makes a mistake like that, there'll be huge consequences, whereas if a judge makes such a mistake, they effectively walk away scot-free. I'm not sure if that's an argument for making judges liable to negligence actions for their decisions, but it does illustrate the consequences and the way in which these type of decisions can have enormous impacts on people. I said in a recent address to the District Court Judges Conference that the childcare jurisdiction of the District Court is by far the most powerful jurisdiction, because while we can sentence an offender in a criminal case to a maximum of 2 years imprisonment, a District Court judge can decide that an infant can be taken away from his or her parents for the next 18 years. So it's an enormously onerous and responsible decision, and it's one that for me personally gives me a lot of sleepless nights when I'm hearing these cases, and no decision that a District Court judge makes in a childcare case is an easy one or is done on the basis of rubber stamping or nodding through. That brings me to the importance in such cases of clear and focused evidence. And once again, I'm borrowing from my colleague Brendan Toll when he reports, and this is from, I suppose, evidence that he's gathered in hearing cases in Dublin, so it may not apply to most of the people here. But sometimes in social work reports, there's not enough emphasis on distinguishing the trivial from the important. We often get lists of chronologies of incidents and facts repeated over and over again in successive reports, which get thicker and thicker because what's happened is the chronology is repeated in each report and then the updates are added. You have hours and sometimes days in childcare cases spent by both sides cross-examining each other, using unfocused evidence, respondents conceding nothing, often entrenched positions taken between the Child and Family Agency and the respondents, the guardians ad litem stuck in the middle trying to articulate the voice of the child, but very often, in fact most often in my experience, being included with the Child and Family Agency as the enemy from the point of view of the parents. So, as I say, the judge has to try and sort of see through all of that and make the best call. So if I would ask anything of anybody here today, is just to bear that in mind when you're next preparing a report, and try and make sure that what the judge is hearing in court is the important rather than the seemingly trivial. Similarly, I think there are some lawyers here. Lawyers for both sides should assist their clients in identifying the core issues in the case to each other and to the court at the earliest possible stage, so that the efforts and resources of all, including experts in courts, are appropriately focused. Once again, that doesn't happen in a lot of cases. Some lawyers approach these things with a very gung-ho attitude, and it's a fight to the death, and they have to win the case for their client. In my view, in a childcare case, there are no winners. If the childcare order is made, it's not a victory for the Child and Family Agency over the parents. If it's refused, it's not a victory for the parents over the Child and Family Agency, because ultimately the child is the person who has to carry the can for whatever happens in court.